Everyone. Like Joseph said, my name is Carl Christian Johannesson. I'm a staff attorney and I just want to give a presentation on managing trees within the right-of-way, what the town board's rights regarding managing the trees are, and the statutory procedures in order to be able to remove or modify the trees in some way. So why is this important? Well, there are two big overarching reasons. You have safety and you have maintenance. It's the town board's duty to both maintain the road at a reasonable level and to keep the road safe. Trees get in the way of sight lines. They make it hard to park or to move the trees or to move vehicles into the ditch areas. And trees can be incredibly unsafe as well. When you run into a tree at any speed, and the speed limit of town roads is 55 miles an hour, it can cause serious damage to the vehicle and the drivers inside. As for maintenance, trees damage roads. The roots just get underneath the road and they cause the road to buckle and shift in ways that it shouldn't, and that creates expense for the towns, something that's preventable much earlier than later down the road when the trees actually start to cause damage. What are some other considerations when dealing with trees? Well, first we need to know what the width of the right-of-way is. A recorded road or a road owned in fee will have 66 feet of right-of-way. That is 33 feet on either side of the center line of the road. For use and maintenance roads, that may differ. All townships need to work within the right-of-way. If they don't, that's trespass. And when modifying trees, well, trespassing, Minnesota law tells us that you pay triple of the damages. So not only do you pay the damage for removing the tree, such as the cost of the removal, but you also pay extra fees on top of that if it's taken properly. The other big thing we want to know is what is the tree or a hedge in Minnesota law? Because sometimes towns go about brushing, and so these can be treated a little differently. Well, Minnesota Statute 160.22 subdivision 7A kind of gives us a definition for trees. That is a woody perennial shrub or vine that's at least 6 inches in diameter and that's measured at the point from the ground, so up from the ground 2 feet up. And a hedge would mean any planted or maintained hedge within the right-of-way. So because of this definition, it's really broad. Trees, I guess, are a little more defined, but a hedge is really in the Minnesota law regarding trees and working within the right-of-way. It uses those terms interchangeably. So if a town is going to remove, should follow similar procedures that you would if you're going to remove a tree. You have to first determine a need. You have to give notice to the owners of the board's intent to brush, and then you have to make sure that no brushing occurs outside of the right-of-way. So now we want to just talk about who owns a tree within the right-of-way, because who owns the tree allows the town to use their rights properly. If the town owns the road, meaning that if the town owns the road, which is incredibly rare, the town owns what is within that road, what is within that 66-foot right-of-way. So don't rely on this as your standard. Generally, a town is going to own or have their rights to the road through easement. So there are 3 ways easement can occur. You can have a recorded easement, and if it's recorded with the county, you do have all 66 feet of the right-of-way to modify. If your road was obtained through use and maintenance, that is under Minnesota Statute 160.05. Those are roads that over a period of 6 years the town has used and the town board has maintained, and we'll go into more detail about what that looks like later. The town can only modify what has been actually used. Platted roads are a little bit different than in the platting agreement or the platting gift. It seems to be also assumed that trees are within the scope of that. So towns have more rights to modifying trees within the right-of-way when the road is platted. For the land owned by the adjacent landowner, the land that's adjacent to the right-of-way, the landowner might have duties and the town cannot touch that land. That would be trespassing, and when you trespass, you have to pay triple damages. So just going back to use and maintenance roads real quick, these are non-recorded roads. These are non-recorded roads that have been used and maintained, so they have been driven on and they have been maintained for a period of at least 6 years. Most town roads or many town roads are obtained through use and maintenance. And so with these roads, you can only maintain what the town has obtained through actual use and use its actual width. Again, these claims are based on Minnesota Statutes 160.05, and this has been litigated over a fairly long period of time. In one of these first cases discussing use and maintenance roads, Barfneck versus the Town Board of Hollywood, actual width is the amount the town uses and maintains. But this doesn't have to be used and maintained on a yearly basis. For instance, you don't grade a road or you don't rebuild the shoulder every year. But just some factors to consider are mowing, whether the town has ditches along that road, what's the back slope, is there brushing, is there plowing that goes into that. If the road is used, the town can only maintain what it has maintained up to. So if that's 50 feet, if the town has only maintained up to 50 feet of that road, it can only modify trees within that 50 feet. And of course, the authority doesn't extend beyond the 66 feet. The 66 feet is the limit of that use and maintenance. So now that we understand how we own trees and what trees are, let's actually get into the tree cutting procedure so that the town can actually work through this process and remove the trees to maintain maintenance and safety. So if you own the road and fee, again, remember this is rare. Like it says here, think Nike, just do it. You can just remove the tree because you own the tree. You own the land. You don't have to follow any procedures. However, it may not be a bad idea to follow the steps that are normal for other procedures, as it just mitigates the risk of litigation. So just determine the need, notify the landowners, and remember, stay within the road. Stay within the 66-foot right-of-way. If you go outside of that, that's trespassing. Now, the bigger issue, when you're holding the road through easement, there are three main ways you can do this. You can first obtain written permission. You must clearly identify and mark the trees that are going to be cut in that consent form, but you can obtain written permission, not verbal. It has to be written. It has to be clearly identified in that writing to cut the trees. And this is the easiest process. If the landowner doesn't have an issue, this would be the first step I recommend, to just go ask for permission, obtain it in writing, and the writing identify the trees. The town can also purchase the trees. This is a much rarer process because not only in the written permission phase or in the statutory removal phase, you have to, there's no payment that you have to give to the landowner specifically. There's no assurance that you'll be able to obtain the tree, and like I said, it can cost more money than the other two processes would cost. And so, again, just not used very often. The statutory removal process. This is the bulk of Minnesota Statutes 166.22. It gives a procedure for the town when the landowner won't give over the tree to the town. Just to begin the process, the town must give a 14-day written notice not only to the landowners, but also to the renters, if there are any people living there who aren't the landowners. And it must also be given to it should also be given to the adjacent landowner. As we'll see later, the other notices do require you to give notice to the adjacent landowner, so it's best to also do that here. So not only the landowner that abuts the right-of-way, but the landowner who owns property next to that landowner who abuts the portion of the right-of-way that has the tree. This notice must be fairly specific. You must advise the right to request a hearing, and the notice must give a specific deadline for the hearing and who to contact. So if this is the clerk, it can be the clerk. If it's one of the supervisors, such as a road supervisor, it can be him. But if you're going to invoke this process, you must have a 14-day written notice. And if the landowners don't request a hearing, the town can proceed with cutting the tree. So this can be a fairly short process. It can be 14 days. I would recommend probably waiting 16 days, so you give the landowner not only the day they receive the notice, but also I would recommend 15 days, sorry. So you give the landowner a day after they receive the notice so that they have a full 14 days to request the hearing. If there is a hearing, the rest of Minnesota Statutes 160.22, subdivisions 5 through 8, discuss what this process looks like. So this process starts with the board determining a time and place for the hearing. This would be done at a town board meeting. So the board would receive the request for the hearing, and then the board would set a time and place for the hearing after receipt of that request. This hearing must, the landowner is effective, so that not only includes the landowner who abuts the land, but also the resident, or the renter, and the adjacent landowner to the abutting landowner. So you may have to notify up to 4 different parties here: the renter, the landowner, and the 2 landowners to the side of that landowner. They must each personally receive 10 days written notice of the hearing. When it says 10 days, it's best to, again, give time for the date of receipt and then the date of the hearing. So in effect, the 10-day notice becomes a 12-day notice. The statute doesn't specify here what the needs for publishing or posting notice for the rest of the town. Obviously, this is an open meeting, so there must be posted notice. And so best practice would be to also publish and post notice in accordance with the written notice. So that would include 12 days or notice 12 days prior to the meeting given to each of the 4 landowners, as well as notice published in the town's newspaper, in its official newspaper, and posted at the regular posting place, just to make sure that we're fully complying with the open meeting law. At the hearing, it is a public hearing of sorts. It is a public hearing of sorts, meaning that not everyone needs to be heard. At a public hearing, anybody who requests to be heard must be heard. But here, only the affected landowners and residents need to be heard. But it's a good idea, just again, good practice. If someone wants to be heard, let them be heard. There's not really a reason to restrict someone from being heard here. At the hearing, you have to determine if the tree interferes with safety or maintenance. It doesn't have to be both, but safety or maintenance must be determined. Issues with that. After the meeting has finished, the town board has to develop a written order, or I should say after the hearings are finished, after the owners have been given their opportunity, the town board may start to develop a written order or resolution containing the reasons for cutting the tree. This resolution must also be delivered to the affected landowners and the renters. The determination may also be to not cut the trees. If the town board doesn't find any risk of safety or maintenance, or then the town board can just decide not to cut the trees, or if it doesn't want to go through the hassle of cutting the trees, if it changes its mind. So as I said before, it's supposed to be laid out in a resolution, and it should be fairly it should be fairly specific into the reasons for the board's determination as to have proper the proper records and the proper reasoning, so that the town board isn't seen as acting arbitrary and capriciously. The owner has 30 days from the receipt of the appeal, or from 30 days of the receipt of the written order, so 30 days within the receipt of the resolution. So this starts after they receive it. Again, best just to assume 31 days here, to appeal the decision to the district court. And this decision, this appeal period, the town board must wait until the appeal period is over before they can do any sort of cutting. There are obviously costs involved with this decision. For instance, in the notice of the written order, so here, just going back to that in subdivision 6. So when you develop, subdivision 7, when you develop the written order and you send to the affected landowners and residents, give a notice as well, notifying the landowner that they have 30 days from the receipt of the notice to file with the court administrator for a notice of appeal. This also goes, the person appealing must also give the court administrator a bond of not less than $500, which is approved by the court to pay all costs arising from the appeal. And again, when that appeal happens, the town board will receive notice of that appeal from the court. So here, just for a brief timeline, and it's not really brief, if the town board invokes this process, they have 14 days to hear if the resident, 14 days, and it should be 15 days, considered 15 days, for the resident to give an appeal or to request a hearing. And then after that request, if the person requests it, the board must send out a notice at a minimum of 12 days after the request of the hearing. So now we're up to 32 days, 27 days. And then after that, the town board, if it develops a written order and has everything finished that night, which is unlikely, but possible, the town board cannot remove the trees up until 31 days after that after that 27 days. So in total, that would be 58 days from invoking this procedure until the town board can remove this if there is a hearing involved and the town board is moving as quick as possible, but it will likely take longer. It'll take sometime between 60 and 90 days if a hearing is requested before the town board can remove the tree. As for platted roads, this is much simpler. This is like fee title ownership. Minnesota Statutes 160.22, the statute we've been discussing. Subdivision 11 allows town boards to modify platted roads to remove trees and hedges without needing to notify the landowner. And so you should still notify the landowner. Like I said, with the fee title ownership, it is a great process to just send out a notice if you're going to remove a tree and just let the landowner know of the board's intent. They don't have a right to a hearing here, so you don't need to notify them in that, but you should determine a need and you should send out a notice. If you're going to remove a tree in a platted road, know your width. It's already recorded, so if you don't know what the precise width of the road is, or if the platted road has deviated from where the original dedication is, seek the plat records. The plat records will help the town board in determining what their authority is in a platted road. Just some other quick issues. Like I said, violations from the town. If the town trespasses and starts cutting trees or trimming trees outside of the right-of-way or not following the proper procedures, they're subject to triple damages. So again, that's not only just paying the trees, but that's paying 3 times for the damages of the trees, and then there may be other fees involved as well. The adjacent landowners. If the town has any issue, or if the town would like to remove the tree, speak to the landowner nearby the road first. It's always good to kind of lay out the town board's position, lay out the landowner's position, and just try to come to a compromise. And we can avoid the statutory proceeding, that lengthy statutory proceeding. We know that landowners can also be given duties within the town road to clear weeds, to clear small woody perennials, to clear some rocks. And this can be submitted, a question submitted to the voters at the annual election. But this doesn't include trees or brushing. This doesn't include trees and hedges. So even if the landowner has duties within the right-of-way, it's not their duty to remove trees, so the town board still has to go through that process. If a landowner decides to start planting within the right-of-way, this can be trees, this can be hedges. That does pose a safety risk, and it does violate Minnesota Statutes 160.2715, which carries with it a penalty of a misdemeanor, but it is best to notify the landowner of their violation and to try to work with the landowner to make sure things don't get more messy than they need to be. Just try to work with the landowner to remove it. And if the issue persists, then you may start to bring more serious, may contact them more seriously, such as sending a letter or asking the sheriff's department to come and assist the town in enforcing that statute. The towns also have a authority to trim trees. There's no statutory procedure on how to do so. And they can't touch trees, or they can't touch branches that are from outside of the right-of-way, but this arises out of the right to maintain the road and to protect public safety. So if you have branches that are dangling into the road, that are dangerously causing issues for the town board, or for drivers on the road, the town board can remove that, and you have to still notify the landowners. When you are doing this, not only don't cut into the private property, but don't even move into the private property to remove the trees. You want to cut the trees within the road and maintain the what you have rights to. Again, don't overreach on the private property. Don't trim at the base of the tree. If the base of the tree is not on the road, don't trim more than needed. Again, if dangling onto the road, maintain that in such a way where the road becomes safe again, but don't go further back. And don't leave a mess. This includes on the private property, which you shouldn't be leaving a mess on the private, because the private property, the town can't go onto, can't trim on. But this also includes the final notes. Know where your road is. Know if you have the full 66 feet or if you have, say, 50 feet. Be wary of how much the town board has and what the town board can modify. Try to resolve these tree issues without having to use that statutory proceeding. It's best to try to remain as friendly and to not use your authority as much as possible, as it makes the landowners feel like they have just more of a say in town business. If you have platted roads, you should, or if you own the roads, you should still notify the landowners of what you're doing so they aren't taken by surprise and they get frustrated with the town's actions in those. Again, know where your road ends. Only modify the road. Only modify the trees within the actual width. Again, if this is use and maintenance, this may be harder to determine. It's always better to be safe than sorry. And if you don't follow these rules, you can really risk a trespass lawsuit, forcing the town to pay triple damages as well as other fees involved. That's the end of this. So now I'll take some questions. The first question is, do townships need to give notice to the landowners for tree removal during the road construction project? Yes. If you're modifying trees within the right-of-way, you have to notify landowners. You better ask again for written permission detailing which specific trees are going to be removed, or you can invoke a statutory proceeding. If you're doing a construction project, that can take much longer and it can really slow down the project. The next question is, can we trim trees that grow on the landowner's land and that hangs over the road? Yes. If it's within the right-of-way and it's causing damage or safety concerns in the right-of-way, you can certainly trim that. But you can't trim that outside of the right-of-way, and you can only trim what is necessary. You're trying to take as little as possible here. All you're doing is trying to keep the road safe, because that is the town board's duty here. The next question is, what's the difference between a platted road and a road by easement? So a platted road is a road given by easement. What I mean by easement is that you have certain permissions on that road. You don't own that land, but you have permission to use the land in a certain way. A common easement would be to, outside of this, would be to use hunting land or use a path on someone's land in order to get to your hunting land. That's a common easement. So there are ways you can obtain easements for roads. You can obtain it by use and maintenance. You can record a road, and usually this is a statutory road establishment process in which you would record the road. And then a platted road, which is where a landowner dedicates to the town a certain area within their land to the town board so that they can develop that area or just have a road within that area. So a platted road is a road that is a type of easement, but it's an easement that is specifically dedicated to the town, and the town isn't doing any sort of taking, and so there's more permission there. The next question is, what is the most common type of road? The most common type of road probably is a use and maintenance road through easement, and then recorded roads and platted roads are fairly similar, and then towns don't tend to own roads outright in fee. The next question is, why was it stated in MADinfo that trees are the property of the adjacent landowner, even if they're located entirely within the right-of-way? So this is going back to that easement question. The town doesn't actually own the road. They don't own the road in fee. They can't sell the road, for instance, or the land within the right-of-way. So what this means is that the owners only give up certain rights when giving it to the town. And because trees are seen as part of the land, the town isn't allowed to modify the land in certain ways. And the trees are part of that certain way in which the town's not allowed to modify the land without properly notifying the landowner that they're going to do so. So again, just real quick, it's not, even though the trees are the property of within the right-of-way, the town doesn't own the right-of-way and all the materials within that right-of-way. It is the adjacent landowner who owns that, and so that's why a town would have to ask for permission in order to remove a tree. Next question is, what happens if a tree in the right-of-way is more than 6 inches in diameter? So if a tree is more than 6 inches in diameter, we know it's a tree for fact. That 6 inches rule, 6 inches, at least 6 inches around and 2 feet high, it might not be considered a tree, but you should still treat it as a tree. But if it is more than 6 inches diameter, it definitely has to be treated as a tree. And so that includes any of the three. And so if the town board was going to modify that, that would include any of the three processes that we discussed: buying, obtaining consent, or the statutory removal process. Next question is, what about large rocks in the right-of-way? Do we need to treat it the same as trees? And is there a time frame that these rocks and boulders have been there that we can no longer work within? I'm not sure. At least the tree statute specifically doesn't discuss that, but if it's providing difficulties to maintenance or safety, even if there isn't a statute, there will certainly be a way in which that the town board can modify that to increase the safety of the right-of-way. I would ask you to email me so I can give you some more specifics about that, but that's a little bit outside of the scope of this presentation. The next question is, how does spraying brush affect all of this? Like I said earlier, spraying brush or brush, just because of its uncertainty within the law, whether brushing is legal without having to notify the landowners. You should notify the landowners of what you're doing. If you are using chemicals, make sure that the chemical does not go onto the landowner's land. So if that means that you have to stop at a certain point and hand trim, that may unfortunately be the case here, but you have to make sure that the chemical does not enter onto the landowner's land or damage the landowner's property. And for brush, you should notify the landowner of what you're doing, at least. Does a cul-de-sac have a different right-of-way more than 66 feet? No. So the road is expanded, sure, and it's expanded. So if you're in the center of the cul-de-sac, the town has a 33-foot right-of-way outside of that point, or down, I should say, along the right-of-way. So if the cul-de-sac, say, extends 33 feet, the pavement extends 33 feet around from that center point, the town doesn't have any rights outside of that pavement. So another question is, landowners are not responsible to clear trees and brush within the right-of-way? No, landowners will not be responsible to clear trees and brush within the right-of-way. That is a town board duty, and they shouldn't. Landowners, we're in a weird state here where landowners can't really do anything, and the town board needs permission from the landowners in order to be able to do something. And so, if the landowner wants the town to modify the right-of-way or to change the trees, to remove trees, the landowner should ask the town to do it for them, just to make sure that everything is being done correctly. Another question is, what's the best way to handle a township residential road that has not had the trees maintained in the right-of-way for many years and is now looking to address it, and there are large trees within the right-of-way? First, the town should probably look into the costs of that. Tree removal is going to be expensive. They're heavy. It takes a lot of time to cut them down. Although this wasn't addressed here, there are certain considerations to make when disposing of the wood from the tree. And some of those considerations include that the tree shall belong, or the cut wood shall belong to the landowner who owns the property that the right-of-way is on, and that the Road Authority will place it onto the landowner's property without doing unnecessary damage. And then the town board will have to either notify or discuss with the landowners what the best process to remove these large trees is. And so that's about it. If there are even with the large trees and they haven't been maintained for a long time, if the road has been maintained or if the road is recorded, and then the town board has rights within that right-of-way. And so I would double check with the town attorney that there are rights within, or that the town board has the rights to, or that those trees are within the right-of-way. And then start with one of the three processes discussed. And then when you remove the trees, put the tree on the adjacent landowner's land without causing property damage. Then another question is, when going to rebuild a road, do you mark the trees first or notify the landowner first? You should mark the trees first so that you know which trees specifically you're going to cut. And then when you know which trees you're going to cut, then you notify the landowner of what their rights are for those trees.
All right, Carl Christian, looks like that was our last question. So to the audience, if you have any remaining questions, we do have about 4 minutes remaining in today's presentation. So we're going to go ahead and make a last call for maybe 1 or 2 more questions. And in the meantime, if you haven't already, go ahead and download today's materials in the extra materials box located in the top right-hand corner of your screen. These materials were sent out previously in a confirmation email, but if you haven't downloaded them, go ahead and download them now. You can simply just click on the file name and click on Download Files. So again, last call for any remaining questions for Carl Christian's presentation today. Go ahead and submit those questions now. All right, Carl Christian, looks like that'll be it for questions. Would you like to go ahead and make a final statement, and then I'll close out today's presentation?
Yep. Like I said, that there are a couple that the town board should be cautious about removing trees. There are a lot of steps involved, and there are there can be a lot of money that needs to be paid if the town board doesn't take the proper steps. If the town board has concerns about whether the tree is within the right-of-way or would just like clarification on the next steps, feel free to call us at Matt. Either Steve or I, the staff attorneys, would be happy to help or guide you in the right direction.
Okay, I'd like to thank our attendees and our presenter today for all participating in today's program. Keep in mind a full program recording will be sent out to all paying attendees at the close of the presentation today. It'll probably take about 1 hour to get that recording link sent out, and it will be sent out via email. So be checking your inboxes for that recording. And until then, thanks again for your participation, and to everybody, be safe out there during this time. Have a great day. Bye-bye.